Hello, welcome to our webinar on everything you need to know about the employment changes that are coming in and some perspective, new things to watch out for. So the topics that we will be covering are all the new leave changes and the additional protection for redundancy. Wouldn't be a seminar without some discussion about union activity and the law around that. What's happening with standards and ACAS guidance that have come out. In particular, we're also going to talk about future changes to watch out for and some interesting cases which link into these topics. And we all better be prepared for a election and what that may bring. I'm going to start by talking about flexible working requests. So for the next set of leave that Lucy and I are going to talk about, they're not yet in force, but they've been received royal assent, and they will be coming into force next year, some a little bit later, but we'll talk through that. We already have the right to request flexible working. The changes will be the ability to make a request 2 times a year, and the employee does not need to give an explanation of the impact of those changes. And the deadline for responding to those requests will be shortened to 2 months instead of the 3, and it's 2 months for the entire process from getting that request in right to the appeal decision. And they will employers must have a meeting with the employee to discuss the change before they finish off making the request. The biggest change will be a day 1 right, so there'll be no qualifying period, of which there are now. Lots of employers are already used to this, so it will be a sharpening of your process. However, there have been some very interesting cases on flexible working requests. Some of us are so sad that we actually do read first instant tribunal decisions all of the time and quite enjoy it. But there's a whole raft of flexible working decisions on hybrid working, which are quite helpful. And what they're saying is an employer is entitled to choose how it works. So it's entitled to be either fully remote, hybrid, or in-site, in location. What it's saying about hybrid working is that there is already inbuilt flexibility in that arrangement. So therefore, when somebody's asking for more flexibility on top of that hybrid working, that's a different consideration. It also has the judgments from judges, which have far better language than I, are putting about the benefits of meeting colleagues and working together with colleagues and having that. The other issue I would sort of say is that we're not settled on the way of work yet. So the pandemic meant we had to, if we were lucky enough, work at home entirely remotely. And then we've had, between then and now, employers coming to some kind of arrangement that is constantly changing. So the amount of work that can be done hybrid and remotely is still under consideration as markets and conditions change. With relation to the day 1 rights, and everybody, whatever political persuasion you are, is supporting this day 1 right. I think you might want to just revisit how you're presenting your jobs and your roles so that people are confident and able to discuss with you at an early stage what flexibility that they may require. Relationships, the employment relationship is based on trust, and I can see why an employer might go through a process, think they're talking about a certain role, and an employee may come in and say, well, no, and that might the employer might think, why didn't you say that before? The employee might think, I might not have got my request. There's just one other thing I'd quite like to mention with flexible working requests. The reasons to refuse them will remain the same, and the employer doesn't need a high level of evidence, but they do need to carefully consider those. And all flexible working requests, when they go to tribunal, are always linked to claims of discrimination. So you're also meeting the indirect criteria. So you have to justify the decision for your working arrangement, so it's proportionate. There has been one interesting EAT case, the Glover case, and that's a case where there was a store manager who went on maternity leave, was scheduled to work 5 out of 7 days, so a 7-day schedule, came back and wanted to request part-time working for 3 days. That was rejected. At appeal, they said you could work 4 days, but those 4 days had to be entirely flexible, i.e. on the rota. She said, I'm a mother, do you know how difficult it is to get childcare, let alone one where I can just pop in on a 7-day rota, especially at the weekend. She instructed a solicitor, they did a letter for action, and the employer conceded and said you can work 3 days, your original request. It's gone all the way to the EAT. The final determination hasn't been made, so it goes back into the tribunal system. So she's not yet got the justice or the injury to feelings award. But what the EAT said was very interesting, because it said if there has been, you have to look at the substance at each stage, i.e. can you justify your decision both in the original decision and at the appeal, and also look at process. And either of those may be discriminatory. The EAT, she failed in the first instance because she never went back to work, save for the 3 days. So the Employment Tribunal said she didn't suffer a detriment, she didn't suffer in any way. And they said, no, the fact that she had to go through all of these processes, there were determinations, meant that there was some discrimination. It's essentially saying that if you've done an act of discrimination, even if you try and remedy it, it will only go perhaps to quantum. There is a paragraph in the EAT which says that, oh, we don't want the appeal not to be a process where people change their minds. And that's what we generally see with our clients, is that there's a real discussion, a revisitation of the issues, a compromise to see if it could work. There is a this case might say you better get the decision right first time, and if you're going to change it on appeal, be very careful. Please, when you're writing your letters on flexible working in the first judgment, say there is an appeal, it has to be subject to an appeal, and that will help you. Lucy, you're going to talk about carers.
Yeah, thanks, Monica. So one of the acts that came in this year is relating to carers leave. So this is a statutory entitlement for 1 week's flexible unpaid leave per year for all eligible employees who have caring responsibilities. Now, we're not expecting this this year. It's expected at the earliest of April 2024. The requirements for this leave is that the employee must be caring for a dependent who has a long-term care need. What's notable about this is that the long-term care need definition is quite broad. So it covers anyone with an illness or injury that requires or is likely to require care for 3 months or longer. It also covers anyone who would be classed as disabled under the Equality Act, and anyone who requires care for a reason connected with old age. I'm sure you can see that that is quite a broad umbrella of people who would be caught by that. Employees are eligible from day one of employment for this leave, and it's in addition to any emergency time off for care for dependents. Now, one of the very interesting things about this leave is that the Act particularly specifies that employees don't have to explain who the leave is for and why it's being used. They don't have to provide any kind of medical evidence to support the fact that they need to take this leave. There's obviously a bit of a risk there that it might be abused, although it is only 1 week and it's unpaid, so perhaps the risk of it being abused is mitigated a little bit. A lot of employers also have leave such as this in place already, so perhaps it won't be as big a change as a lot of the lobbying groups were hoping it would be. On the same topic, we've got another type of family leave that's just come in. So this is for neonatal care, and this is a Leave and Pay Act. Again, it received royal assent on the 24th of May, But this one we're not expecting until April 2025 because there's so much secondary legislation that goes along with it being paid leave. The Act provides up to 12 weeks statutorily paid leave in addition to any maternity, paternity or shared parental leave that they might be eligible for. To be eligible for this leave, the newborn has to have been committed to neonatal care for a continuous period of 7 days, and they have to have been committed within 28 days from birth. The leave accrues at a rate of 1 week for every week that the newborn is in care. So if they're in the neonatal unit for 3 weeks, the eligible parent gets 3 weeks extra neonatal care leave. Now, as I say, it's a paid right. So the leave itself, the employee can take as a day one right, but the right to pay, they have to be employed for 26 continuous weeks. And we're expecting, obviously the legislation isn't in yet, but we're expecting the pay to be on the same rate as other family pay.
And we would just say that if you have enhanced maternity pay provisions, you might want to just think about how this change may impact that and what you would like to do in these scenarios, which is relatively rare, but still an issue for those who have those difficult births. So there will be, again, another change which will enhance the maternity redundancy protection. The statistics all show that females that have availed themselves of maternity leave or have had who have been pregnant before the maternity leave, they're at higher risk of redundancy, and we see this drop out. So what the proposal is that you will know that a woman that's on maternity leave, she has an automatic right to be offered a suitable alternative role if that arises during her maternity leave. It's one of the only examples of positive discrimination in the UK framework. It does have to be a suitable alternative role. And what this piece of law will do is extend that period for 6 months after the return from maternity leave, so giving a longer period. So if the redundancy is done in that period, again, this trump card will come out to play to protect this group that is disadvantaged in terms of the current regime. Strikes. So this is a very particular piece of law, again, coming into effect, but it's this idea that there's got to be minimum service levels in certain industries. So that's what this Act will protect. I suppose the more significant issue that we're seeing, and you can see it run through, is that the government makes changes. Either the House of Lords don't like those changes, so they don't come through, or they get overturned. And so the law that was enacted where you could use agency workers in a strike is no longer good law. So employers and their contingency planning will need to go back to pre that, which was always the case until relatively recently. We've just done a slide so you have a framework of when the legislation is due to be impacted. I would say on the strikes, depending on where the next election is, that may not even happen. And there needs to be, I think, a wholesale relook at the bargaining position between employer and employees and the union's intervention in there.
Yeah, so one of the interesting things that's come out this year is some updated guidance from ACAS on reasonable adjustments for employees with mental health conditions. Now, obviously, this is a hot topic issue. It's something that employers frequently have to deal with when their employees go off with mental health related sickness absence. Now, the first thing to caveat this discussion is that employers should remember that a mental health condition might be a disability under the Equality Act. It's not definite, it's very dependent and taken on a case-by-case basis, but it's sensible for employers to act as though it is a disability to mitigate any potential risks there, and also for the benefit of themselves and for their employees. I would really recommend that both employers and employees go away and read this guidance. It's not very long, but it's got some really, really useful tips, both for employers and for employees specifically, about what both parties can do to sort of come to the table and help make good, reasonable suggestions to make their working lives better. But our main takeaways on this, firstly, is to review every case on a case-by-case basis. No two presentations of mental health conditions are the same. An employee who's got depression and anxiety might well have very, very different symptoms and coping methods than another employee. And it's important that employers are reactive to that and understand that one fix won't necessarily work for another employee in different circumstances. On a similar vein, you've got to keep these reasonable adjustments under review. ACAS recommends that you look at it at least once every 6 months, because conditions do change. As with a physical disability, what's good at one point in the person's life may well change, and the business needs might change. And it's really important that you keep revisiting that and don't assume that you've addressed it, it's a tick box exercise, and that's done. The third big takeaway is that whilst it is the employee's job to suggest these reasonable adjustments, and the guidance is really useful for setting out to employees how they should go about making these requests and what things they should take into consideration when asking for reasonable adjustments. But it also suggests that the employer should be active in this. The employer shouldn't sit back and wait for the requests for reasonable adjustments to come. They should suggest ideas, they should engage with the conversation. It works so much better when it's a two-way street, and you're much more likely to find a compromise that works for both parties if both parties engage properly. On the screen, there's a couple of suggested adjustments that ACAS have recommended. Obviously, these won't all work for every situation, but I would recommend that you have a look at these, have a think about them, and perhaps if you're trying one and it's not working, try a different technique. It might be that changing line manager works where flexible working wouldn't necessarily fit the situation and the business needs. So yeah, really, really good guidance. I really recommend that both employers and employees take a look at it.
It is good guidance. I think there does need to be more considered conversations about getting to the root of the issues, especially about reasonable adjustments. So you see that employees will look up their rights and they will take a view on what they're entitled to do. And what they think is reasonable may not be what the employer thinks is reasonable. And it's having those measured, considered conversations so they understand why it is not reasonable and also what the journey looks like. So many employers are really good at doing reasonable adjustments, at least in the short term. And then they're wondering, well, the person's not still performing or the absence continues, and putting up with high levels of absence or recurring absences or poor performance is a grounds for dismissal eventually via a process. And you're better off addressing those early on so the employee knows this is what good looks like for both parties. And you're not having those painful conversations late on when they'll be taken by surprise. And the final thing I would say is that employers make adjustments all of the time. It's the give and take of a relationship, but you're really rubbish at keeping a record of those adjustments. You have to rack your brain for all the amendments that you have done. Also, you're not very good at perhaps assessing the burden when flexibility is given to one on others, i.e. the impact on the wider team and managers in dealing with these issues or making these adjustments, and that needs to be better captured. I've got this slide. I don't know why I've got this slide. I do know I've got this slide. The standards have come out by the British Standards Institute. That's why they're called standards. It seems a bit weird that the word standards is used for your period or your menopause. To Lucy's point, while there is commonality, everybody's journey is very different, and these standards are very helpful, practical guidance for how an employer can support with these issues, and none of them seem particularly onerous, but it's this idea that you're opening up the discussion, you're looking at those issues, and again, they're likely to change. Well, I hope they change as you go through the menopause. So some future changes to work out. So third-party harassment, you're entitled to be very confused about this, because at one point there was a piece of law which an employer would be responsible for third-party harassment. So this is when contractors come on site and harass your employees, or generally customers and clients, where your responsibility for them. And it was supposed to be a wide change that protects all protected characteristics. What we've been left with is a watered down protection against sexual harassment for third parties. And the wording was that the employer had to take all reasonable steps. Now it's just reasonable steps. However, this coming to the forefront and employers seeing what their staff may be dealing with, especially in retail, this increase in crime, increase in violence, increase in bad language, as most employers that we are working for, regardless of this law, is addressing and putting measures in place to protect their workers. And I don't think it should just be relating to sexual harassment. It's inappropriate to harass a worker due to their disability or their race, or any of the protected characteristics. So there is some work to be done about how you let customers know or clients know these are the standards that's expected from you, and the provision of support to employees. I think fundamentally, regardless of this is a health and safety. Nobody comes to work and it is extremely stressful. It's just an increasing circle. You have to go into the mental health ACAS guidance if an employee is being confronted by a level of aggression which is just not acceptable and they don't have the support work, support arrangements around them. There are changes to be happened to paternity leave. We don't know when, but there will be an enhancement of those changes and we set those out for you. There is currently a consultation on occupational health. I do urge you to go and look at that and input into that. We have a real disconnect at the moment between what services an employer will offer them, and lots of you offer very good enhanced support systems. There's a disconnect between employees effectively engaging with them and how you want to have a culture where they're proactively using those resources. It may indeed turn into an obligation to use them so that they maintain their well-being, and the disconnect between the provision in the NHS for care and the role of occupational health. So it is worth looking at this in a holistic approach, because even with the best private medical insurance, it's not available to all, and it won't perhaps deal with the issues that the employee has, which ultimately will mean that they will run out of sick pay and will put them into a difficult situation. So please, I would ask you to look at that and put your viewpoint on that. The ICO has been very busy drafting new guidance. So there's guidance on the data subject access requests. That doesn't really give much comfort to an employer that's being inundated with them. So that's mainly a rewording and some clarification. But there is an interesting point in that new guidance on data subject access requests. It says that you cannot carve out the right not to do a data subject access request in a settlement agreement. So you need to just revisit that and look at what you would want to do with that. We think there is a different way you can achieve that, but by carving it out in a warranty or something like that. And you may want to keep putting them in because it's more of a deterrent. And it's this idea of having a clean break and just saying you can't do this for a certain period of time. There is new guidance on the ICO on how you manage health records. So this is the managing of sick records, occupational health records, you know, health schemes, all of that data. Of course, an employer can rely, including for drug and alcohol testing, and you can rely on maybe the contract. You may be able to rely on legitimate aim, and this is where the ability to have that data derives from. If an employee does not give you their health data, actually then you're entitled to make a view on the information you have and take it as you want. And that's not particularly helpful to an employee, I don't think. But there's some interesting examples. So there's an example in the guidance which says you are putting a piece of technology out. That technology is a wearable watch, like I've got on now, and that tells me where I'm to go and what product I'm to collect. And it's to help with work organisation and productivity. The employer probably has a good reason for doing that, and you agree with that. But in the same way, when the employer is telling them, this is what we're going to do, this is the device that helps you do that, and this is what we'll be tracking, so you're getting consent. If you add into that, oh, and by the way, we're also going to check your health, your blood pressure, so that we know you're not unduly stressed by this job. If you put it in just one document, they're saying that that may not be freely given express consent, i.e. you have to separate the health aspects out, so not linking it in a large document. And that does make sense because that is sensitive personal data. The guidance also says, interestingly, it uses the word that health data is the most sensitive personal data. It might be a good idea, you probably have seen this when you've been doing data subject access requests, but really looking at how you're holding the data, I would say you do need to hold all of the health data for throughout the person's employment and for some time afterwards, because it protects against litigation claims, having the evidence of what was done and when. It's very important that you have that claims go back years, even if they're building up to the last point, which has to be within a certain time period. But what you would perhaps need to do is look at how your data is moving around the organisation, and are there any tighter measures? So when you're sending minutes of welfare meetings, who's seeing those, what measures are in place, that it's not just the employer or the manager, but who else has access? And they might be entitled to have access, but the employee is entitled to know that, this is who's got the data, they're also going to keep it confidential. So just look through that and look through whether you're complying with that, particularly on the health records. Before I talk about the election and the possible, depending if you're a betting person, but the odds are looking like there will be a change of government, before I look at what the Labour manifesto is saying, let's just look at some things that there is a Working Smarter paper by the current government that has a couple of things that are quite interesting in it. This government has been obsessed since the holiday pay claims, because that costs employers a lot, about rewriting the working time rules. And there's some lessons, I think, to be learned there with equal pay, but I'll talk about that in a bit. And what they're saying is they will be allowing rolled up holiday pay in certain circumstances, and I know that there'll be certain clients who genuinely have bank employees that do not take advantage of that. Genuine holiday pay works, rolled up holiday pay works for them. There's also another interesting piece of legislation which is proposed, which says restricted covenants should be only limited in total at any level to 3 months. We are utterly out of kilter with every other jurisdiction. So you may need to think about those and how you are protecting your confidential information, and using the advanced technology to see where you're, how you can protect it. There's some very good ways in which you can track your confidential data, but it won't be about restricting employees. So if there is an election, well, there will be an election, and it's coming very quickly. Apparently, the politicians don't want to be on our doorsteps in December, so it might be as early as autumn changes. The government has done, the Labour Party has done a very detailed manifesto. It's detailed in their wish list, not detailed in how they're going to implement it. And they haven't moved very far. When you've been speaking to what they want to do, they haven't moved far. So they are setting out, this is their agenda and this is what they aim to do. And they will have to hold their feet to the fire, A, to the electorate if they promise this, but more importantly, to the unions who will demand this as part of the rationale for supporting the Labour Party. So we will see some significant changes which you should be looking at, seeing how they will impact you and having a discussion and about actually how would this work, lobbying for how it will be practical for your organisations, so that any government understands this concept about if it's too detrimental, what impact will that have on an organisation which has an impact on the employees. But this will be this concept of an employee ownership scheme where they own 10%, and there will be a worker representative on the board up to a certain percentage to keep that balance of viewpoints. There will be a Ministry of Employment which will enhance and increase workers' rights. I hope they get more money than the current employment tribunal system, because at the moment it is quite hard to argue for proper access to justice if you have to wait so long to get a case heard for both perspectives. And you will see there is no firm proposals, but this idea that all of those issues like redundancy and statutory pay will increase. I don't know from which fund it will increase, but those provisions. But a couple of the major significant changes is that there will be a worker status, and that means that only those that are genuinely self-employed, and I'm not talking about one-man contractors under umbrella companies in or outside of IR35, it's when you're genuinely got a contracting company that's coming in to provide you services, for example. If you don't fall within that class, you'll be classified as a worker and you will have day one rights. And day one rights means all of the employment rights, including unfair dismissal. So I don't think there's anybody on this webinar, there's certainly not anybody in this room that can say they've always recruited right first time, all the time. And this idea of having a probationary period and, you know, again, being very clear with an employee why they're not succeeding and the responsibility an employer has if they've invested time in recruiting somebody to make it succeed. There'll be a process for them, but there will be very different expectations, and the benefits of having contractors won't exist under a Labour government so much for the ways of working. There will be more union power. So there will be easier for unions to be recognised. There will be sector collective bargaining. So this will be looking at pay and working conditions across sectors. For equal pay, it means that there is in the manifesto this ability to assess pay in different employers but in the same sectors. And there will be a duty, like we have on collective consultation, on redundancies and cheapie, if there is a change of technology. It is really important that you do put your mind to these changes, because it allows there to have reasoned debate, so there is a meeting of minds. I did read in the manifesto, there was this line about how the unions were, you know, the forefront of getting furlough pay. But that was a meeting between employers, government and the unions. And when they work together, it can lead to real excellent results. And it's this idea of compromise. But what we have is too much of companies not accounting for their profitability and not showing that transparency and where it's being invested, and unions protecting certain sectors with certain classes of workers and creating an imbalance, perhaps in that, as opposed to taking a holistic approach. I'm just going to touch on some interesting cases which link back to these potential changes. So the first one is ASTA equal pay claim. And I think this is really relevant to the wider issue because we know what's happened in Birmingham Council, and part of that was the huge £760 million equal pay liability, which has led to their bankruptcy. And the question, and I don't know the answer to this, anyone that does, please let us know. I don't know who is going to pay for that, because clearly these are females that have won their case, or the principles have been decided. Who is going to pay for that? And the impact of having such big awards on organisations and the wider community. Slough residents will tell you their woes of having a bankrupt council and the impact. So it's maybe perhaps looking more holistically if we're getting these big awards. I mean, I would be arguing that pensions could be augmented if they needed to find the salary, but there's some big debates to be had. But on the private sector, the ASTA equal pay case, we are now moving to the more interesting debate about whether is a store worker doing work of equal value than a worker in a distribution centre. So it's this equal value type of work. And what we know is that there's been a leaked report which shows that they are on the skills matrix and the what is required of the job. They are scoring the same, if not more, than the distribution workers. And this is also an example of how the ways of work are changing. So historical concepts of heavy lifting and manual work and strength-based work are being replaced with more machinery and more automation, so there's less decisions being made. So you're seeing that, but generally employers should be at least dealt with the easy one of like work, so there should be no female earning less than a male in their organisations. That is not as clear cut unless you do the data analysis on all the pay groups, and then moving to doing some comparative work. And, again, working with the unions to say, well, what does good look like? If you have too large a liability, that will not lead to job protection or job in the UK. And I think that's the goal that both sides are working towards. Another interesting case is forced to serve, and I've set it out for you. Now, this is the fact that the law protects both gender critical and gender fluid views. So each would be in a protected characteristic. And in this case, it was a researcher who expressed her views of being gender critical. This is where the view is that you are born a particular sex, and that does not change. She expressed personal views, and there were complaints made, personal views in a personal Twitter account, and colleagues saw this and they made a complaint, and she was exited out of the business. And you can see the award that she got, and part of that award was to do with not properly digesting the issues and the reaction. There is a little bit of mob rule in that if enough people say something is wrong, people react to that. And the wording that was used on the exits and to describe this decision led to the Injury to Feelings Award. It's about having a really respectful culture. You do not have to agree with other people's views. They don't need to impact you at work. You should not be discriminated against because of them, but how you express them, outrage that you show, does not necessarily impact workplaces. There are debates to be had, but really, generally in the employment relationship, these don't really come to the forefront except in terms of respect. Whistleblowing. So again, both the Equal Pay Birmingham cases started in 2012, this one started in 2013, and here we are talking about them now. So Duty has recently got her award. This is a case on whistleblowing, and she said that we've been Ofcom breaches and breaches for bonuses. Whistleblowing is so important at the moment because we have just seen the Letby case and the fact that there were whistleblowing allegations there. We've seen the post office fiasco, and therefore it is a hot issue. However, I think employers do need to revisit their whistleblowing policies. A whistleblowing policy should be for those big issues like regulatory breaches, like huge health and safety systematic breaches. It could be policies that are discriminatory, but it's the health and safety, the fraud, the breach of your regulatory authority. What we're seeing is that everything is labelled as a whistleblowing. Whistleblowing investigations are different to employment investigations. It's different from looking at a grievance from one individual. And they can go into either category. An employer should be looking at the types of grievances getting, whether there's any commonality in that. But the investigation that's required to get to the root of the problem is different for a whistleblowing. And when you read the facts of Duty, it is very common. She makes a whistleblowing allegation, and then the water is muddied because you suddenly decide to have a without prejudice conversation with somebody. You suddenly try to micromanage them. Their performance is suddenly an issue. And the timeline of what happens and when is really important to establish. And it means for managers that you can't just sit on performance issues, you have to nip them in the bud so that the sequence of events can be determined. We've now finished. We're going to, Lucy's going to look at her emails to see if there's any questions. So I should have given her a few more minutes to do that.
It's okay. So yeah, we've got a question about flexible working requests. So if an employee has been working from home for a year or more, but their contract says that their base is an office address, do you need to change the contract?
So there is two issues there. It's the difference between what the contract says and what custom and practice is doing. And you would be right to revisit this issue, and the contract should reflect the reality. Now, why contracts haven't changed is because people don't quite know what was happening at the pandemic. You know, we operate hybrid working, but it's a very give and take one, and it seems to be working at the moment now. It may not. I can definitely see this sense of people working, that changing, and employers becoming hardened to the amount of days and the regularity of those days. And if we've got a recession, that may be more so. But in those circumstances, you might be right to revisit and say, is this working? Do I need to change it, or do I still need to have the contract to say it's working now, but we reserve the right to bring you back into the workplace? And this is just my personal view, but I do share it when I'm doing seminars in front of employees. I do worry if a job is so remote that it would be done in a different jurisdiction. So I'm worried about the loss of employment opportunities if somebody says their work can be utterly done remotely with no connection. There is always a nexus between jurisdiction, i.e. where you work, and your contract. And there are lots. That's not to say it's just, I'm just saying, can we just revisit that, have a check, and is it working? There's some quite good guidance about hybrid working, which says there needs to be a bit of thought about what work is being done at home and what's being done in the office, so that there's, you know, the maximisation of each place and their benefits.
Brilliant. So we've got a question about protected characteristics. Just, is there anything in the pipeline to add to the current list?
Oh, there is. Oh, I don't know who asked that. That's a really good point. And when you said it, I just thought, oh. So under the Labour manifesto, they will make social economic status a protected characteristic. And I don't think they're going to be protecting Boris and privilege. It will be the fact that the most privileged and underrepresented people in society are not getting the opportunities, and that, you know, we're not really a meritocracy at the moment. It's harder for them to get onto the job letter and the education system than it's ever been before. So yes, there is, under a Labour government, there will be that change.
So another question regarding maternity redundancy protection is what should employers be doing to enable compliance with this new protection? So for the example they've given is, should they keep vacancies open for a few months prior to maternity return?
So the law's not in place yet. What makes us feel very uncomfortable is when an employer waits and then makes the redundancy. Now, most employers can't wait. There's lots of people that are impacted in redundancies, and we are seeing more redundancies. So I don't think employer may have to change what they do now, but some employers have always said, you're on maternity leave, we've got this obligation, we won't make you redundant now, we'll see, we'll see whether there is another job that comes up. And, you know, this means that you get more holiday, it might mean you get slightly more redundancy pay because you hit an anniversary. And we can see that if you do that in your accrued 30 days holiday that you're adding on to your maternity leave. So there is some provisions to do that. Again, the difference is that what would you do for others? And I think you can justify it, but not beyond that at this particular stage. So I would be saying it would be hard to say, I'm going to use my trump card for somebody who's currently outside of the protected period, because there has been cases where a male solicitor was made redundant because of this law, and he effectively argued against that. So I hope that's helpful. It's mainly to do with the timing and how you treat the woman on maternity leave and the options that are available. Another thing that you could do is say, okay, we are making you redundant, but we're going to keep on sending you any job vacancies for the next 6 to 12 months. They might seek to extend their time with their child or not get another job. Was talking to me about the cost of children the other day, and I thought, oh, I don't think that's a luxury many people have. So there's things to do to work around it, but at the moment it's all about the timing and the ongoing support you give to a female in that situation.
And the last question we've got is, to what extent do you see the introduction of the public interest test for whistleblowing as an improvement on the previous good faith test?
That's a really difficult question. I do think it needs, so the good faith test is a good faith is that it's related to the individual. So if I think Lucy has, as my employer, has done something wrong, I genuinely believe it, but it's mad, there's no rationality to it. But I genuinely think it is. I genuinely think that you have breached health and safety when she's done nothing of the sort. That's how low the good faith test is. It used to be that the public interest test and that good faith was subject to some objectivity. And I think that that is particularly relevant, because whistleblowing is about something that impacts not just the individual, it impacts the public. So if you create a product that goes to market that is unsafe, that is whistleblowing. If you pollute our national waterways and you report that, that's whistleblowing. It's not just to do with the employment relationship or even a class of employment, I would argue. It's to do with something that is much bigger, which of course impacts employees. So on the duty case, she was complaining about how bonuses were allocated. That does seem to me to be more of a personal employment impacts, maybe a group of workers and how that may be doing. It falls in that category, not what I would be saying is a public interest thing, unless the bonus money was being carved up in another pool and being spent somewhere else, in a slush fund. That's where I would say it would then fall into that category.
I think that's all our questions so far. I don't think there's any more coming in.
Thank you very much for joining us. If you have any further emails, questions, you can always email Lucy and I, and we hope you found this seminar useful. Thank you very much.
Thank you. Bye.